Is a mediated or facilitated process appropriate with complaints alleging sexual misconduct? This is one of the questions I encounter often and a good question to ask of each situation. My practice also places an emphasis on facilitation rather than mediation. So we always ask, is this matter appropriate for a facilitated just resolution process? In answering this, consider these questions. What is the intended process? Does it involve engagement that keeps faith with the principles of just resolution to repair harm, achieve real accountability, and bring healing to all parties? Is the complainant willing to participate? This might involve exploring with the complainant's support persons, and appropriate persons with special expertise whether such a process seems helpful and constructive. This exploration may happen through the Episcopal office, through a support person, or during a time of preparation with a trained third-party facilitator. There could be times when a parent or spouse submits a complaint alleging misconduct perpetrated against a child or family member. In most cases, I do not consider it appropriate to engage in a just resolution process when allegations involve children or youth. Some exceptions for me relate to cases that have wider involvement of professionals or relate to addressing healing within a congregation or ministry context as described in paragraph 362.1f. In the matter of adults, consider to the extent possible the experience of the person who was potentially the target of harmful behavior. Is the time right? This is not only a question about readiness along persons' journeys of healing, but also a question of actual time available to move through a process. With attention to the discipline and the feasibility of convening engagement, either virtually or in person, even if not face-to-face, is there enough time to prepare well, include all persons that would be helpful for a process, and then carry out the process to a conclusion? In some situations, those requesting a facilitated process have a sense that a couple of hours of contact time is all that is needed to reach a just resolution agreement. However, in my professional practice with matters related to sexual misconduct, a more constructive process includes time for preparation with each party, often by phone, in addition to time for facilitation. A professional trained third party can also assist in bringing a facilitated process to a close when agreement cannot be reached or cannot be reached at the time. The facilitator is a steward of the process, and it is vital that the process not become too rushed, too slow, or too burdensome for participants. Is the respondent willing to participate? Is there capacity to potentially recognize and acknowledge harm? Is there some acknowledgement of basic events and respect for the described impact of allegations by all parties? If there is a wide disparity in describing basic events or a lack of capacity to understand impact, it is likely that a facilitated process could devolve into deep disputes and potentially lead to further harm. Persons do not have to agree on all the facts, but acknowledgement of core events and their impact is what opens up possibilities for repairing harm, achieving accountability, and paths of healing. Are the necessary parties willing to honor the agreement? In practice, I invite persons to make decisions by consensus, meaning that persons may not agree on all things, but they agree that the path forward, described in an agreement, is best for all. If there is a sense that a party intends to seek other remedies if not satisfied with an agreement, it might not be wise to engage a process. If possible paths of accountability and healing impact clergy appointment status, it is important to have consulted with the bishop and cabinet about potential outcomes. If potential remedial measures involve boards of ordained ministry, conference funds, or similar, it will be important to have consulted in process about the ability to follow through on these. Generally, as a matter of practice, if there is agreement about a change in status for a clergy person, that change is agreed to by the clergy person and entered into through appropriate disciplinary process. In order to promote open and frank conversation, what is shared within the context of a just resolution process is confidential. However, transparency about the engagement of a process and outcomes can contribute to healing and accountability. There may also be specific language in the agreement about disclosure and how to communicate about any agreements. Who will facilitate? When a just resolution process will be pursued, the expectation is that a trained and impartial mediator or facilitator will be selected to carry out the process. Some considerations specific to complaints of sexual misconduct include: does the facilitator or facilitators have experience in working with matters related to sexual misconduct? Are they trauma-informed and resilience-oriented? Consistent with the Book of Discipline, are cultural, racial, ethnic, and gender contexts valued? Would co-facilitators be beneficial in this situation?